Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements and navigate through the intricacies of the insolvency proceedings. Let us discuss one very important case today. It is known as the Raman Ispat case, wherein the Supreme Court confines the applicability of the Rainbow Papers. This is Paschimachal Vidyut Vitran Nigam Limited, that is PVVNL versus Raman Ispat Private Limited and others, which was decided on 17th of July 2023 by the Honorable Supreme Court of India. The specific issue of whether Paschimachal Vidyut Vitran Nigam Limited, which is the appellant, could enforce a security interest created over the assets of Raman Ispat Private Limited, which is the corporate debtor, outside of the liquidation proceedings under the IBC, was settled in the negative. More importantly, the Honorable Supreme Court confined the applicability of State Tax Officer versus Rainbow Papers to its own factual circumstances, effectively quarantining Rainbow Papers from the jurisprudence on treatment of government dues under the Code and allied regulations. In the Rainbow judgment, it was established that the state, through the creation of a security interest under the Gujarat Value Added Tax, held status of a secured creditor as defined by the IBC 2016. Let us look into the factual background of the case. The appellant, which is PVVNL, filed an appeal before the Honorable Supreme Court, being aggrieved by the decision of the Honorable NCLAT, wherein it had rejected PVVNL's appeal against an order of the NCLT Allahabad. The NCLT in its order had allowed an application directing the district magistrate and Tehsildar of Muzaffarnagar to immediately release a property which was previously attached in favor of liquidator of the respondent, that is Raman Ispat Private Limited, to enable its sale and thereafter distribution of the sale proceeds in accordance with the provisions of the IBC. In 2010, PVVNL and CD had entered into a contract for supply of electricity. The said contract provided that a charge would be constituted on the assets of the CD in case of any outstanding electricity dues. Now, PVVNL raised bills for electricity dues from time to time. However, it continued to remain unpaid. Hence, on January 12, 2016, PVVNL attached the properties of the CD. And on January 23, 2016, the Tehsildar created a charge on the CD's properties, thereby restraining a transfer via sale or donation, etc. On April 11, 2017, CD got admitted into CIRP upon filing an application under Section 10 of IBC. Then on January 31, 2018, the NCLT passed a liquidation order and appointed a liquidator. On March 5, 2018, the DM ordered auctioning of the CD's properties for recovery of outstanding dues. On August 21, 2018, the NCLT directed the DM and Tehsildar to release the attached property to enable the sale and distribution of the sale proceeds in accordance with the code. On May 15, 2019, the NCLAT dismissed the appeal of PVVNL and did not interfere with the findings of the NCLT. Now, aggrieved by the order of the NCLAT, PVVNL approached the Honorable Supreme Court for appropriate reliefs and remedies. Now, let us look at the interpretation of government dues under Section 53, subsection 1E. The analysis in the above section was important for the court to understand the nature of the debt owed by the CD to PVVNL. This eventually led the court to also analyze the conflicting nature of the state legislation, in the present case being Uttar Pradesh Electricity Supply Code and the IBC, when it came to determining the nature of the creditors and the priority of their claims during a CIRP. The court opined that owing to the hierarchy stipulated in Section 53, government dues have to be understood separate from dues owed to secured creditors. Additionally, dues payable to corporations created by statutes need not necessarily constitute government dues. Such corporations may be operational, financial, or secured creditors, depending on the nature of their transactions. Whereas, on the other hand, dues which are payable to the treasury, such as the tax and tariffs, etc., broadly fall within the scope of Article 265 of the Constitution as government dues, and hence governed by Section 53, subsection 1E. Therefore, the Honorable Supreme Court has held that dues payable to PVVNL do not fall within the description of government dues, as under Section 53, 1E of the IBC. Now, let us look at the findings and observations of the Honorable Supreme Court. The court affirmed the validity of the security interest created in favor of the appellant and clarified that the dues payable to statutory corporations like the appellant and not to the central or the state government are to be classified as financial debt or operational debt, depending upon the nature of the transaction entered upon with the CD. However, such dues do not fall under the ambit of the dues owed to the central or the state government under Section 53, 1E of the Code. The Rainbow Papers was distinguished on facts as the corporate debtor in that case was undergoing insolvency proceedings, as opposed to the corporate debtor in the present case, which is undergoing liquidation. So in the Rainbow Papers, it was the CIRP, whereas in the present case, it is the liquidation. Further, the court dwelled into the waterfall mechanism. The court held that waterfall mechanism is enshrined under Section 53 of the IBC, which provides for the order of distribution of assets. Accordingly, Section 53 confers government debts under Section 53, 1E and operational debts under Section 53, 1F lower priority in comparison to the dues owed to secured financial creditors. It is imperative to note that a secured creditor must make an informed decision at the very outset of the liquidation process, whether or not to relinquish its secured interest. The rationale behind giving higher priority to secured creditors who relinquish their interest was provided in the report of the Insolvency Law Committee in 2020, which noted that Section 53, 1B of IBC intends to replicate the benefits of security, even when it has been relinquished, in order to promote overall value maximization. The court further held that in Rainbow Papers, even though the Gujarat Value Added Tax Act sought to bring the government dues under the definition of secured creditors, however, the legislative intent, as gleamed from the IBC, was to create a separate category for secured creditors and the government dues, thereby giving a lower priority to the government dues. The court further reaffirmed the importance of the hierarchy of claims under Section 53 by reaffirming that every change in the waterfall mechanism is bound to lead to cascading effects on the balance of rights and interests of the secured creditors and the operational creditors, and even the central and the state governments. So friends, we see here how the Honorable Supreme Court has clarified the government dues vis-a-vis the secured creditors under the IBC. And also it has clarified the earlier judgment delivered in the case of the Rainbow Papers. So thank you, friends, for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.